Hey, what's up, guys? Tonight I want to get into the motion to suppress and memorandum support Pennsylvania search warrant for a white Hyundai Elantra. Comes now Brian C. Koberger by and through his attorneys of record and hereby submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all evidence gathered by law enforcement uh, as a result of the entry into and search of Mr. Koberger's vehicle. Now, personally, I believe that the warrant that they used to search his vehicle was an illegal warrant. This court should apply Idaho's exclusionary rule and law into this search. Pennsylvania law enforcement violated Mr. Koberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Information about the client's locations taken from his phone must also be excised due to being gathered from an invalid warrant. Now, see, here we're talking about the IGG again. If you remember, Dawn Daniels, when she applied for the search warrant for Brian's apartment there in Pullman, also applied for the search warrant without using the IGG because she had a feeling that the IGG would possibly be thrown out at a later date. So, well, like it says right here, law enforcement's unconstitutional use of the investigative genetic genealogy, and thus nothing in the warrant should remain. If Don Daniels can do a search warrant without using the IGG, why can't Pennsylvania you do a search warrant without using the IGG? Due to the haphazard way in which law enforcement has kept and disclosed records in this matter, the following are the facts as best the defense can tell. On December 28, 2022, Trooper Leary of Pennsylvania State Police became aware of the objective of arresting Mr. Koberger via the Moscow Police Corporal Payne. On December 29, 2022 at 4:44 p.m., a magistrate in Pennsylvania issued a search warrant for Mr. Koberger's vehicle. On December 29th at 2022 p.m., the magistrate in this matter signed an arrest warrant for Mr. Koberger in Latah County. The affidavit for the warrant was signed by Moscow Police Department Detective Payne. The basic facts Payne used to support the search are described in a separately filed motion pursuant to Franks v. Delaware. The facts and issues are incorporated herein without repeating them. At 2:43 p.m. on December 29th, a criminal complaint and probable cause order was filed in this matter. At 10 p.m. Eastern Daylight Time and 7 p.m. Pacific Time, Pennsylvania, SWAT began preparations to arrest Mr. Koberger. Despite weeks of constant FBI surveillance, Pennsylvania law enforcement did their own surveillance starting at 11:15 p.m. and that was Eastern Daylight Time. And despite the facts that weeks of constant FBI surveillance showed Mr. Koberger was unarmed, intended to go for runs around his parents' neighborhood, police decided attacking Mr. Koberger within his parents' home was the best option. Okay, really, was it the best option? Couldn't they have taken him like while he was out on the run or out on the hike? Like it's stated right here. Surveillance showed Mr. Koberger was unarmed, intended to go for runs in his parents' neighborhood. So why couldn't they get him while he was out for a run in his parents' neighborhood? Why did they decide to destroy his parents' home? See, that's what I don't get, guys. Why would they destroy his parents' home? If they had another viable option of arresting him, and just, like the FBI has stated, he went for runs in his parents' neighborhood. Why not take him that way? Why wait until he's in his parents' home and do that pre-dawn damn raid, destroying his parents' house? And they even stated he was unarmed. Were they trying to say, okay, well, if you did this in the pre-dawn hours, we're going to do it to you? And that sounds really, really petty, guys. It does. It sounds very freaking petty. Why would you want to destroy his parents' home just to take his butt down? Why couldn't you get him while he's out on his run? This court should apply all. Okay, on December 30th, 2022, at 1:14 a.m., Pennsylvania SWAT and federal agents raided Mr. Koberger's parents' home. During the raid, law enforcement found Mr. Koberger's vehicle in the garage, seized it, and later searched it. Okay, they seized it and then later searched it. Well, I would be applying for a very valid search warrant for the vehicle. I wouldn't just seize it and search it. That would be construed as illegal search and seizure. If you're going to seize it and then search it, that's what it would be construed as, illegal search and seizure. This court should apply Idaho's exclusionary rule and law to this search. The first question this court must determine is whether there is a conflict of laws in this matter and whether Idaho law or Pennsylvania laws, the validity of the search warrant for Mr. Koberger's automobile and necessary relief, unlike the issue of arrest warrants, cases involving multi-state investigations have produced far less case law. In fact, the defense could not find a precise point for the state of Idaho. The issue, however, has received some attention in academia. Professor Kerr argued that his article for the Harvard Law Review that the jurisdiction where the crime occurred should control the investigation is done, but that states and or the federal government should provide some form of authorization to each other to participate in each other's criminal investigations. or incur cross-enforcement of the Fourth Amendment. As it stands, there are at least 5 different approaches to the increasingly common situation. Fortunately for the court, Idaho and Pennsylvania do not differ in their approaches to the enforcement of the Fourth Amendment. Fourth Amendment analog provisions. Both do not accept the good faith exception. Thus, this court can likely afford to leave as an open question which forum's exclusionary rule applies. However, it is clear from the grounding of the exclusionary rule in Article 1, Section 17, that evidence obtained in violation of the Constitution must include. Thus, Mr. Koberger argues that the Idaho Constitution exclusionary rule must apply, and its basis lies not only in deterring police misconduct, and yes, there is a whole bunch of police misconduct in this, guys, because exclusion of constitutionally mandated and judicial integrity demands it. However, it remains to be determined whether the actions of the FBI and the Pennsylvania State Troopers should be viewed through the lens of Article 1, Section 17, or its analogs. It is not at all clear whether a search should be judged by Idaho standards or reasonableness, or that Pennsylvania, or in the case the FBI agents by the Fourth Amendment, as noted, Professor Kerr would have Idaho's reasonableness apply in that the FBI and the Pennsylvania State Troopers were acting under its authorization. This approach must also mesh with the older cases, such as U.S. versus DIRE, and that was 1948, looking to the laws of the state where the defendant was arrested in the absence of a federal permitting, in the absence of a federal law permitting the arrest by a federal agent for a federal law violation. In this matter, Idaho authorities requested assistance from the FBI and the Pennsylvania State Police. Thus, this court should be required to apply Idaho search and seizure law to their actions in Pennsylvania. However, the concept has its detractors. McGlynn argues that when the CITES officer is performing the search, they should only be held by upholding their own laws. While that position has merit, as it does not require a citrus officer to get a rundown of the differences between their law and the trial state's laws, it remains that the Idaho Constitution is not merely concerned with deterrence to officers who misbehave. Moreover, it is of concern that such rule would permit forum shopping. After all, if Idaho law enforcement may take advantage of a laxer restrictions in a different state, they may be simply pause their investigation until their suspect is in the new jurisdiction, or in the case of the FBI, state law enforcement could at any point, even within Idaho, call upon federal agents with the far laxer rules of the Fourth Amendment. Finally, it must be said that there is very little daylight between the Idaho Constitution and the Pennsylvania Constitution. If anything, Pennsylvania appears to have more stricter warrant requirements for particularity. Commonwealth versus Grossman. Pennsylvania law enforcement violated Mr. Koberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. And yes, I do believe that they did illegal search and do an illegal search and seizure on his vehicle without a valid warrant. And I wholeheartedly, I do believe that if he's in Pennsylvania and the killings happened in Idaho, Idaho would have would be the controlling state running the investigation. So why is Pennsylvania and the FBI doing their own independent crap with the arrest warrant? And yeah, because you have Payne up in Idaho with the arrest warrant, and then they're transferring it to Pennsylvania to arrest him. So why didn't they go ahead and do the arrest warrant there in Pennsylvania? With Idaho running the show, they could have had Pennsylvania do the arrest warrant, do the search warrant, and it just feels like it's Keystone Cops. It feels like the FBI don't trust the Moscow Police Department because the FBI refuses to turn over the cast report. And then you have Mallory basically copy and paste and everything from Blaker's affidavits, and that's fishy as all hell. And then you have Mallory not doing the full cast report, and you had Cyrus state that without the AT&T tower logs, that the cast report is just a piece of paper. And you have Brett Payne stating that he lets people smarter than him finish his work. Okay, so exactly why should we believe anything coming out of the MPD? Because clearly they are in way over their heads with this case. They really are. They're in way over their heads. Because if you look at it, there are a bunch of small-town college cops who enjoy harassing college kids for bogus-ass noise complaints. And this was the first time a quadruple murder has ever happened in Moscow in a long time. And I actually believe what Steve G said at one point, that they are in way over their heads. Rosendahl, Payne, Blaker, Mallory, they're all in way over their heads with this case. Look at Chief Fry. He retired. Look at Chief Lanier. He retired. Look at the judge, John's judge. He retired. Pennsylvania law enforcement violated Mr. Koberger's Fourth Amendment rights by entering and searching his vehicle without a valid warrant. Okay? Police cannot search a vehicle within the curtilage of a home without a warrant. Mr. Koberger's vehicle was in his parents' garage in a home where he was an overnight guest. Overnight guests have an expectation of privacy in the home where they stay. Therefore, he had an expectation of privacy in the contents of his vehicle, and a warrant was required. Okay, so that right there says that they basically seized his car in his parents' garage and searched the car without a warrant in his parents' garage. That's complete and utter bullshit, I believe. I do. How are you going to search a vehicle without a search warrant? That would be illegal search and seizure. It would. And just like with the IGG, why, if you're surveilling Mr. Kohlberger, the FBI, and you're seeing this guy put his trash in the neighbor's trash can, why not go get his trash out of the neighbor's trash can? Why get his dad's trash out of their trash can? If you're sitting there, surveilling this guy and watching him put his trash in the neighbor's trash can, why not just fucking go and get it? There's just something with this case, guys. There really is. There's something with this case. If you think he did it, go get his damn trash out the neighbor's damn trash can. Don't take his dad's trash. You're sitting there watching him, dumbasses. For a search warrant to be valid, the judge issuing the warrant must rely on an affidavit or affidavits sworn to before the judge or by testimony under oath, and recorded that established the grounds for issuing the warrant, State versus Nunez. Any discrepancy between the items for which there was probable cause and their description in the search warrant requires suppressions. It is clear that the issuing magistrate himself, he is to fulfill the constitutionally mandated function of interposing an independent intelligence between the law enforcement officer and the citizen, must actually and in fact draw the interference from the evidence presented to him. It is for this reason that the courts have insisted the full facts from which interferences might be drawn and information necessarily to determine the reliability he places before the issuing magistrate. Finally, a criminal defendant must challenge the veracity of an affidavit used to obtain a search warrant. Upon a preliminary showing of a warrant's deficiency, the defendant must prove by preponderance of the evidence that international or reckless falsehoods were included in the warrant affidavit and were material to the magistrate's finding of probable cause, or that material exculpatory information was deliberately or recklessly omitted. An omission of exculpatory facts is material only if there is a substantial probability that had the omitted information been presented, it would have altered the magistrate determination on probable cause. Whether an omission was intentional or reckless might be inferred, in part from the relative importance of the information, its exculpatory power. The challenge pursuant of this section of the motion is separately laid out in Mr. Kohlberger's motion for hearing under Franks. The motion and proffer are incorporated but not repeated herein. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. Where information in a warrant was obtained via violation and Constitution, Idaho courts excised that information. Mr. Koberger has argued in a separate motion that the genetic genealogy investigation in this matter was done in violation of the Constitution. Additionally, he has argued that there would be no investigation into him without the original constitutional violation. It is not that the result of the IGG sped up the investigation. Instead, they focused the investigation on Mr. Koberger, a person whose only connection to this case was his mode of transportation and the shape of his eyebrows, two identifications of little to no value, and previously argued, as the Idaho Supreme Court explained, while the initial burden is showing a factual nexus between the illegality and the evidence, the state must show it would have been discovered anyway. The state cannot make this showing without IGG. There is no case, no request for his phone records, right there. No request for his phone records. Surveillance of his parents' home. No DNA taken from the garbage outside, because the IGG analysis is the origin of the matter. Everything in the affidavit should be excised. Now see, where she states, no DNA taken from garbage out front. What she's talking about, guys, is his DNA was not taken. Sorry, guys, I'm still sick. His DNA was not taken from out front. His dad's DNA was taken from out front. That's what she's talking about. Separately, the information gathered via the warrant for Mr. Koberger's AT&T account and the pin trap and trace device warrant should be excised for the reasons set out in those warrants. Mr. Koberger's request this court suppress all evidence obtained by police via the warrant that permitted them to search his car. As explained above, the warrant lacked probable cause as written. Now, what do you guys think? Do you guys think it lacked probable cause? I think it lacked probable cause. Let me know down in the comments, guys. I really think it lacked probable cause. This entire case lacks probable cause. It's all a circumstantial evidence case. That's all it is. Circumstantial evidence. Yep. Like always, guys, like, subscribe, and comment on my channel. Hit that bell notification for any new uploads. And sorry I was coughing during the video. I'm still a bit sick from this pneumonia. You guys have a good Thanksgiving Eve, and I hope y'all have a happy and safe Thanksgiving tomorrow. This is Robert with True Crime Podcast. I'm out, guys. Happy Thanksgiving. Peace.